Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orndlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. It looks like we do have everyone present, so we do have a quorum. I did want to note that Assemblyman Wheeler's having some issues with his camera today, so he is joining us, but I'm not sure if we'll have him on video or not. So anyone who might be watching, just please know that that's what's happening this morning.
Dressed up and everything.
We'll take your word. We'll take Assemblyman Wheeler's word that he's dressed up and everything, but I don't know if we'll have him on video this morning. So want to say good morning to the members of the committee. Good morning to members of the public who might be watching this proceeding online this morning, and welcome to day 19 of the 81st session of the Nevada Legislature. Before we get started, a few quick housekeeping matters. If you are on the Zoom, if you could please mute when you're not speaking, that'll help with the audio feedback. For presenters, there will be a few different presenters today helping me present the bills. Please remember to try to state your name each time before you speak. If you forget to do that, I'm sure Vice Chair Wynn will remind you, because it's not really a normal thing to do in conversation. The other couple of things, we do expect courtesy and respect in our interactions with one another. We don't always agree on policy, perfectly fine, but let's make sure we're being respectful to one another and to the legislative institution. And then finally, many of us are working with multiple screens and devices to participate virtually, so please don't see it as a sign of disrespect or inattention if we are looking away to try to look at exhibits and process everything that's going on. So with that behind us, members, you'll see that we have two bills on the agenda today. I'm going to be at least presenting or co-presenting both of these. So at this time, I'm going to hand the virtual gavel over to Vice Chair Wynn to conduct the two bill hearings. Vice Chair Wynn, I'm going to now go to the witness table, and it's all yours.
Well, this is fun. Thank you. And at this time, I will open the hearing on Assembly Bill 104. This bill revises provisions related to wrongful convictions. I know that Chair Yeager will be presenting this, and he emailed out his conceptual amendments this morning on AB 104. So hopefully everyone in the committee was able to see that. And I believe it is his intention to be presenting off of these proposed amendments. So if we will welcome to the hot seat our very own chair, Chair Yeager, please proceed with your presentation when you are ready.
Good morning, and thank you so much, Madam Vice Chair and members of the very hardworking Assembly Judiciary Committee. My name is Steve Yeager. I represent Assembly District 9 in Southwest Las Vegas. It is my pleasure this morning to present Assembly Bill 104 to you. Joining me today for the presentation are representatives from the Attorney General's Office, including Second Assistant Attorney General Christine Brady, Chief Deputy Attorney General Heather Proctor, and Deputy Attorney General Cheryl Cerez. Madam Vice Chair, with your permission, what I would like to do is provide a brief background on Assembly Bill 267 from last session, then hand it over to Ms. Proctor to discuss how that bill, Assembly Bill 267, has been working in the real world. She'll then take the committee through both the bill and the conceptual amendment before we open it up for questions. Is that acceptable, Madam Vice Chair?
That is. Go ahead and proceed.
Thank you. Steve Yeager again for the record. And, before I get started, I wanted to let the committee know that I've been in discussions with the Las Vegas Metropolitan Police Department, the Attorney General's Office, and the Public Defender's Office about potential amendments to the bill. We haven't reached any consensus there yet, and I'm not sure if we will. So I don't think it makes sense to talk too much about what some of those proposals might be at this time. But if we ultimately agree on further amendments, I will certainly explain those to the committee and go over them before we would vote on the bill. Sometimes in the legislature, we refer to bills as Christmas trees, and sometimes people want to hang ornaments all over those Christmas trees. So at this point, we're not quite there on deciding whether those ornaments are going to be acceptable, but stay tuned. So to really understand the bill that you have in front of you, Assembly Bill 104, you have to first understand Assembly Bill 267 from last legislative session. Assembly Bill 267 from last session did something that I think is really important. It provided compensation for those who had been wrongfully convicted and incarcerated in our state. Many, many people helped make that legislation a reality, and I'm most thankful for their work. It was certainly a long time coming, as Nevada was one of the minority of states that did not provide such compensation. For those of you who were on this committee last session, you'll remember the hearing on that bill was very, very emotional, as we heard from Mr. DeMarlo Berry, who had been wrongfully incarcerated in Nevada for nearly 22 years. Yet when he testified, he was full of grace and forgiveness. I'm really not sure that there was a dry eye in the committee room once Mr. Berry finished his testimony. I know that not many of us have free time in this legislative process, but if you do have even an hour or two in your day, I would certainly recommend going back and watching Assembly Bill 267 from last session, because I think it gives you the sense of the enormity of what we have the privilege of doing in this building. And I'm proud that that bill, Assembly Bill 267, had bipartisan co-sponsors, passed both houses of the legislature unanimously, and then was signed by Governor Sisolak. So I tell you all of that because the bill you have in front of you, Assembly Bill 104, makes some changes to that legislation that we passed last session. And those changes really came as a result of feedback from the Attorney General's office, because it's the Attorney General's office who defends these lawsuits. They're technically the named defendant in the lawsuit, and they negotiate these lawsuits. So they were able to provide some suggested changes to make the law clearer, easier to understand, and easier to administer. It has been an absolute pleasure to work with them on the language in this bill, as well as the proposed amendments over the last few months, and I'm very thankful for their collaboration on this issue. So what I would like to do now is to hand it over to Ms. Proctor and anyone else at the Attorney General's office to just give you some additional background on how Assembly Bill 267 has actually been working out in the real world, and then take you through the bill, the conceptual amendment, and then we would be happy to answer any questions. So thank you so much, Madam Chair, and with your permission, I'd like to hand it over to Ms. Proctor.
Go ahead and go, Ms. Proctor.
Thank you, Madam Vice Chair. Good morning. For the record, my name is Heather Proctor, Chief Deputy of the Attorney General's Office. On June 17, 2019, the legislature passed Assembly Bill 267, codified in NRS Chapter 41, which authorizes a person who is not currently incarcerated for any offense and who is wrongfully convicted and imprisoned in this state to bring an action for damages and other relief in any state district court. AB 267 became effective October 1st, 2019. Since the enactment of the wrongful conviction compensation statutes, the Nevada Attorney General's Office has worked with claimants in balancing the state's obligation to be fair and just with its responsibility to ensure that it is not overwhelmed with enormous monetary liability. To that end, the office ensures every claimant complies with NRS 41.900 and establishes by a preponderance of the evidence that they did not commit the crime for which they were incarcerated. As with any new law, through enactment, the Attorney General's Office discovered that existing law required clarification, uniformity, and certainty for the state and claimants alike. This led to the proposed amendments in AB 104. To be clear, the intent of the wrongful conviction compensation statutes, as addressed in the 2019 legislative history, is to provide monetary support for persons recently released from incarceration to permit them to begin rebuilding their lives, re-entering society, and doing what the state can to restore their dignity and life after years lost wrongfully incarcerated. An award does not place blame or find fault. Rather, the person is provided a chance to live a normal life with a certificate of innocence permitting the claimant to move forward without the wrongful felony conviction looming in their background and at every traffic stop, and money to start that life and the necessary provisions of life, from medical care and counseling to advanced education to reentry and financial literacy programs. As many of these claimants are also seeking monetary compensation against a county or state agency through a Civil Rights 1983 action, which typically takes years to resolve, the law includes an offset provision requiring a claimant to reimburse the state for the money paid for the length of incarceration. Section 1 of AB 104 revises NRS 41.910 to clarify the documents to be sealed following the issuance of a certificate of innocence and the confidential nature of such proceedings. Section 2 exempts the state from the restrictions of an offer of judgment, as well as prejudgment and post-judgment interest. Again, I return to the intent of the bill, which is to permit the claimant sufficient funds to restart their lives while they await larger settlement funds from civil rights matters, without incurring unnecessary additional costs for the state. Section 3 provides clarification for the claimant and the state in calculating the monetary award for the length of incarceration. During the committee hearings on AB 267 in 2019, both Assemblyman Yeager and the Innocence Project stressed that the payments under these new statutes were not intended as a double award. Again, it was intended only to permit the claimant the ability to return to a normal life pending settlement of a 1983 action. To that end, Section 4 clarifies the language of the offset provision to bring it in line with the original legislative intent. It also clarifies for all parties what settlement funds are subject to the offset. Assemblyman Yeager mentioned that he'd submitted some amendments, which I'd like to briefly discuss. In implementing the law, the Attorney General's office determined that caps were necessary for the additional benefits a person could claim under the statute. No such caps currently exist. We found this meant, for instance, that a person wrongfully incarcerated for 5 years would be entitled to a lesser amount of damages, but the same amount of benefits in both monetary value and length of award as somebody wrongfully convicted and incarcerated for 30 years. A person should not receive benefits for a period that exceeds their original incarceration. Again, the intent of the statute is to give the person assistance in returning to normal life, not a lifelong windfall. In addition, the Board of Examiners requested some certainty in the costs that would be sought from the Reserve for Statutory Contingency account. This led to the additional proposed caps in Section 3 of the amendment, which serves 1, to clarify the costs a claimant can pursue, 2, to maintain the assistance a claimant requires to return to normal society, and 3, to create certainty for Board of Examiners to budget for the additional expenses by providing a maximum potential cost for those additional expenses. Finally, Section 4 serves as a gatekeeper for the offset provision. It is possible for a claimant to commence a civil action in any state or federal court throughout the country, not just in Nevada. It is impossible for the Attorney General's office to track every claimant throughout every potential state or federal court for years to determine when and if they receive another settlement related to their wrongful conviction. The proposed amendment in Section 4 places the burden on the claimant to inform the state of any such settlement so that the state can enact the offset provision and recover the appropriate funds from the claimant. Thank you, and I would like to open it to questions.
And Madam Vice Chair, if I could, before we open it for questions, I just wanted to make one more comment. This is Steve Yeager for the record. Much like the last couple days, I think you're going to hear some opposition testimony that wishes the bill to go further or to not have any monetary caps on damages. And, I think what I'll say about that, and we haven't really talked about this in this committee necessarily, but, sometimes the prosecuting agency in criminal cases is in fact the Attorney General's office. So, it is the state prosecuting the case. But more often than not, prosecutions are initiated by local government entities such as county district attorney's offices. So I mention that because, in these cases that we see, I think we've seen so far, more often than not, the prosecution and the investigation was done by a local government entity. And I think you can ask yourself, well, why is the state providing compensation if something went wrong in the local government prosecution? And I think Ms. Proctor really hit on that, which is, existing claimants, they probably have claims against the local government in the form of a 1983 federal civil rights action. And those cases take a long time to go through the system. So in setting this up, what we wanted to do is basically have the state be able to make that person as whole as they can up front. And if and when that person recovers from the local government, then the state would be reimbursed. And of course, the state legislators, we need to balance the need for justice and fairness with our fiscal responsibility as well. And I think in coming up with this bill and the amendments, what we realized is it was really hard for the state to budget for what they would potentially be on the hook for because we didn't really have limits and well-defined definitions. But I wanted to mention that because I appreciate the opposition you're going to hear. And I, like many of you, would probably love to give even more compensation. But, I think as stewards of the state's monies, we have to be very aware that we have to be fiscally responsible in this role as well. And so I'll just say that we're still working on some concepts, but for now, I think this is the most fair way to process these claims, realizing it's not often the state that really did anything wrong in these cases. And that's not to say the local governments did anything wrong. People are people. We certainly make mistakes in what we do. And I think the intent here was to make sure we're compensating fairly, but protecting the state from huge financial liabilities as well. And for those of you here last session, that was a very delicate dance to have to conduct. And I wasn't real sure this bill was going to pass, I think, until the last day of session because we had to get it through the money committees. And so with that, Madam Vice Chair, I appreciate the time to make those additional comments, and we would be happy to answer any questions from the committee at this time.
Thank you. And I'm kind of looking at the chat right now, so I don't see anything here. Oh, it looks like Assemblywoman Summers Armstrong may have a question for you regarding Section 4.4, so I will turn that over to her.
Thank you, Madam Vice Chair Nguyen, and thank you, Chairman Yeager, for this presentation. If you could just elaborate on Section 4.4 and just kind of expand on what this means, what costs are. I'm not clear if the calculation of the award of damage or settlement amount pursuant to this section must not include. Would you please just kind of clarify that, please?
Yeah, Steve Yeager for the record. So I can, probably the best way to break that down is there are two buckets of awards that a claimant would get. So the first one is based on the amount of time they were incarcerated, and that is not in Section 4. You're going to see that in Section 3 of the bill. So that's just how many years were you in times a monetary value per year. Your question relates to Section 4, subsection 4, and that section talks about these additional benefits that can be granted to the claimant, such as housing assistance, such as financial planning, educational assistance, healthcare. So what it's essentially indicating on that is that, and I'm going to pause for a second because I want to make sure I answer your question right. And Ms. Proctor, maybe you want to take over because I think I talked myself out of the right answer on that one. So I'm sorry about that.
Thank you. For the record, Heather Proctor with the Attorney General's Office. Assemblyman Yeager was exactly right on point. There are essentially three different areas of funds coming into this. The first, as Assemblyman Yeager mentioned, is the compensation for the years incarcerated. The second are the attorney's fees, which are capped at $25,000 pursuant to the statute. The third, as he mentioned, are these additional benefits, the medical care, higher education, financial literacy programs. What Section 4.4 clarifies is if there is a subsequent award from a 1983 action or another civil action challenging the wrongful conviction, the individual is responsible for paying back only the lump sum or the amount for the time incarcerated. They do not have to reimburse either the attorney's fees or those additional benefits such as the higher education and medical care.
Do you have any follow-up, Assemblywoman Summers Armstrong? Go ahead.
That is a perfect explanation. I was just concerned that they would have to include attorney's fees, which we all know can be quite steep, and that would have a serious effect on what they would be able to maintain as part of their as reciprocity. You just hate to see people have to give back everything after they've had to fight just to survive. So this is great. Thank you so much. I appreciate the clarification.
And if we can go next to Assemblywoman Cohen.
Thank you, Vice Chair, and thank you for the presentation. I'll certainly never forget last session's hearing. So I have a question about Section 4, Sub 3, and the notification required by the claimant to the Board of Examiners within 6 months of receipt of an award of damages. And I understand that that we're not looking to give two different awards, and that we're hoping to get people started off on the right path while they get their federal claim resolved. But I'm a little concerned about this because the claimants have often been in prison for years and years and years. Some of them were very young when they went into prison, and they're coming out years and years later to a lot of hoopla, a lot of people coming out of the woodwork, a lot of things going on, and learning to, frankly, become part of society. And I'm a little concerned about putting this obligation on them when I would imagine their head's just spinning and is going to spin for months and months and months, or even years. So that does concern me, putting the obligation on them when they, even though we are offering some financial literacy help, they're still, juggling a lot. So can you address that, and if that's really fair to put that obligation on them?
This is Steve Yeager for the record. I'll try to answer that and then ask Ms. Proctor to assist if need be. Certainly understand the concern. I think the protection there is that Ms. Proctor could verify this. I think without fail, these claimants have attorneys who are working on their cases, whether it's here in Nevada or the federal case. So I think having the attorney as a safeguard is going to help understand that there is an obligation for the claimant, if they're to receive a future settlement or award, to notify the state within 6 months. And I would anticipate in most of those cases, they have the same attorney. So, it obviously reads as the claimant, but I think practically speaking, it's going to be counsel for the claimant. And, the reason that provision was put in, as Ms. Proctor stated, it's hard for the Attorney General's office to know about all these cases going on. So to protect the state and make sure the state is reimbursed if there's an award against a local jurisdiction that's, essentially covers the state's costs, that the state gets reimbursed. So I understand the concern from the claimant perspective, but I think the appearance of counsel is almost always going to solve that problem, I think, from a practical standpoint. And I would certainly hand it over to Ms. Proctor if she wanted to add anything that I missed.
Thank you. For the record, Heather Proctor, Attorney General's Office. I would just echo what Assemblyman Yeager stated. Unfortunately, we do not have the resources to track all of these potential claims. And I can give you an example. One of the individuals who was mentioned during the legislative history last session, and one of the individuals we've already settled with, was Kathy Woods. A significant event in her case occurred in the state of Louisiana. And so realistically, she could have initiated a 1983 action in Louisiana, and we would never have known. That's the issue that comes with this. In addition, as I mentioned, these 1983 actions can take many, many years, and we simply don't have the resources to continue checking in and determining if these individuals have received a subsequent payment. As Assemblyman Yeager mentioned, we have not had any cases yet where the 1983 action the individual was not represented by the same counsel as in the state action. So we have worked closely with them. But again, we settle our matter and the 1983 action continues for several years thereafter. So this is simply a way of ensuring that the state can get some of that benefit back, that amount for the incarceration back at some point, and allow the state that recovery, because again, the purpose of this is not a windfall. It's to keep that individual healthy and getting him back on track so that he can proceed with this 1983 action. We also mentioned in our state orders in all of these actions that is a requirement that the individual notify when they receive that windfall. We just want to have that in the statute just as precaution. And I believe Ms. Brady would like to pitch in on this as well.
Thank you, Christine Jones Brady, for the record. Thank you, Vice Chair of the committee. The other thing I wanted to point out is that the language is may language, permissive language. So failure to do so may impact an additional benefit provided under the statute. And when we were discussing this amendment to the bill, we were contemplating that it's permissive because the person would have an opportunity to appear before the BOE or appear before the court that presided over the matter in the first place. And they could, if they were having some sort of difficulty or they were maybe in a mental health institution for a while or whatever was going on in their lives, they could explain and maybe provide good cause. So it's permissive language rather than shall. And that's why we went with permissive.
Thank you for that. Oh, sorry. And just a follow up. Well, I appreciate all that. Although I mean, I would point out that Ms. Woods does have mental health issues, so that is a little concerning to use her as an example when hopefully she has counsel, proper counsel that's doing its job. So I guess I would just like to follow up with, but is the claimant themselves given something that says, this is what you have to do, these are your obligations, so that they know? So if there's a problem with their attorney, if, attorneys die, cases get passed off to other attorneys get fired. And also with Ms. Woods, you mentioned the case in Louisiana, if there is different counsel in different states, I just can imagine a scenario where something falls through the cracks, and this is that thing. So yeah, and then
Okay, so my name is Cheryl Cerez. I'm the Chief Litigator at the Attorney General's Office, and I can assure you that in every order that is entered in the state court litigations, that the Attorney General is responding to these wrongful conviction compensation cases. And we did provide Chairman Yeager with a copy of all of the orders that get entered. We do specifically include in the order granting the monetary compensation, we include the exact language from this offset provision. And it specifically includes language that if they get a future award, they are obligated to do the payback and to notify the state. So yes, the actual claimant gets the language that they have to do that.
Okay, thank you. I appreciate that. Thank you, Vice Chair.
No problem. And next we can go to Assemblyman Wheeler.
Okay, thank you, Madam Vice Chair. I missed this committee last session, was somewhere else. And I'm sure it came up at that time, but how many people are we talking about here? How many of these cases are we looking at, in the last 10 years? 100, 2? What's the volume here?
Steve Yeager for the record. Assemblyman Wheeler, we certainly missed you on the committee last session, and we're glad you're back with us. And I'm glad you asked that question because I think all of us presenting had neglected to mention that there is an exhibit up on Nellis that is a memorandum from the Attorney General's office that runs down the cases that so far have been filed and negotiated, and then I guess all the cases that have been filed at this point. Some have been resolved and some have not. And I'll give them a chance to kind of give you a rundown of that. But I wanted to note the original bill that we passed has a provision in there that basically says if at the time the bill was passed, there was an existing person with a wrongful conviction claim, that they only have until September 30th of 2021 to file that claim. So we're going to know by September what the potential liability is for the state for the potentially existing claimants. Now, of course, if someone has a wrongful conviction after the date of the bill, then that would be a future liability that's as of yet unknown. But I would like to, I don't know if Ms. Proctor, if you want to just give sort of a quick rundown of how many cases have settled, what the monetary amount was, and then how many that are active or how many we think might be out there that would come before the September 30th, 2021 deadline.
Yes, for the record, Heather Proctor with the Attorney General's office. In that memo, we have had 7 cases filed to date. 4 are settled or in the process of settlement. Mr. DeMarlo Berry received $2.25 million for the wrongful conviction itself, for the incarceration. Mr. Reginald Mason received $975,000 for his almost 14 years of wrongful incarceration. Ms. Woods received $2.85 million, and that was for more than 30 years of wrongful incarceration. And Mr. Steese, his documents are currently pending in the state court for settlement, and for his 18 years, we have recommended a settlement of $1.35 million. We do have 3 other cases currently pending, Mr. Dialba, Mr. LaPena, and Ms. Labato, and the potential for those are a total of $3.19 million just for the portion of time that they were wrongfully convicted. All of those costs do not include other benefits to which they may be entitled. I would also add that when this AB 267 was first discussed in 2019, the total number of potential recipients at that time was 13. Of that, 5 of our 7 individuals were on that list, and we have identified a potential additional 2 individuals. As Mr. Yeager stated, they have until September to file those claims, and that is for everyone who could potentially claim a wrongful conviction prior to October 2019. We have not received any claimants since then that were not contemplated in that prior list, or who were not wrongfully convicted several years prior to the enactment of the statute.
Okay, thank you very much. Follow-up, Madam Chair?
Yes, go ahead.
Thank you. Again, Assemblyman Wheeler for the record. So we're not, talking about huge numbers here of wrongful convictions. I don't think anyone really wants to not compensate someone when we did them wrong. It should be. We basically ruined their lives. But what I'm saying is, you're talking 10 or 12 people, and that's backdated to all times. So we're not looking at, this happening weekly.
This is Steve Yeager for the record. I sure hope not, Assemblyman Wheeler. I think, with some of the policies we've passed on this committee, we're trying very hard to make the criminal justice system more accurate and better so we don't have these outcomes. This bill really came as a result of just a few very egregious cases that you know, I think everyone would look at those cases and just know that a big injustice happened. So it came from a desire to compensate them. But I would be the happiest person in the world if we never had another claimant bring a suit under this bill. And we'll keep trying to make sure that our criminal justice system has the appropriate safeguards. But to answer your question, I don't anticipate we're going to see a huge number of these. I think the big ones we know about are already in the system and being processed. And again, hopefully we don't have any in the future.
Yeah, thank you, Assemblyman. I just wasn't worried about the money. I'm worried about how many bad cases we have out there and what do we do to fix that. That's the true background here, I think.
Thank you, Assemblyman Wheeler. Next up, we have Assemblyman O'Neill, and I believe he has a question regarding Section 3. And I will turn it over to him to ask his question.
Thank you, Madam Chair. Not being an attorney, help me understand, please. On Section 3, we actually delineate, or it was delineated back in 2019, exact amounts for X number of years incarceration. If you go to Section 3, subsection 2, subsection 4, it says counseling services, and it doesn't have an amount. Housing is $15,000 a year. Section 6 says if awarded, and they're both if awarded. Once again, it doesn't give an amount. I'm confused. One part, we have a set amount, and then we're also going to provide an open check for counseling, an additional $15,000 a year for 10 years for their housing after release, and an open check for the financial literacy. I'm not against the program. I'm concerned about the open check status, you might say. And also, to me, the award should include the housing. It's ambiguous, if awarded. I'm trying to figure out what would be the argument between not awarding and awarding. It's just confusing to me. Probably my question was too.
No, thank you, Assemblyman Steve Yeager, for the record. I'll answer the first part of that. In the conceptual amendment in that subsection you're looking at, Section 6 indicates that all the damages that are compiled in that provision, sort of the supplemental damages beyond the years, they're limited to no more than $100,000 per calendar year. So there is a cap on the calendar year basis. And then they're also limited to the length of time you spent wrongfully incarcerated or on parole. So for instance, if you got compensated for 5 years, your damages under the other section are going to be limited to 5 years, a maximum of $100,000 a year. So the reason we did that is exactly what you're saying. It was really hard for the Board of Examiners to try to budget with basically lifelong unlimited potential awards, but now they have a maximum, so they can at least have that in reserves, realizing the maximum might not be reached. And then in terms of, you know, the court awarding specific items or not, I would ask either Ms. Proctor or Ms. Cerez to just explain how the court makes that determination of what of these benefits to award and the process for reimbursement, because they're the experts on that. I have not been in court to see those happen.
Thank you, Assemblyman. For the record, Heather Proctor with the Attorney General's Office. What we have done thus far is, with all of the benefits that are listed in subsection 2 of section 3 of the amendment, is to work with counsel for the claimant to determine which benefits, if any, they would like to receive. And because the language of the bill is fairly open, it is essentially up to the claimant which of these they would like to pursue. Thus far, we've only had one individual actually seek housing assistance. Most of them have sought the counseling, most have sought some sort of medical insurance, and most have sought potentially higher education. So it is almost a checkbox as to which of these expenses the individual would like to request, and we work with them and we incorporate that into the orders that we submit for the settlement to the court. But by putting in that subsection 6, we hope to put a cap on the total amount rather than a no caps at all, which is what exists now.
Thank you for that. Does that answer your question? Do you have any follow-up, Assemblyman O'Neill?
No, just how to work the mute button at times. No, I want to thank him for clarifying my confusion on it. I appreciate it.
Perfect. Thank you so much. Next, I think we have a question from Assemblywoman Krasner.
Thank you, Vice Chair Wynn. So a couple things. Section 4, sub 3 of the bill. So a person who received compensation from this state and his or her action brought pursuant to NRS 41.900, whether through an award of damages or a settlement, and then who receives a civil settlement or award relating to his or her wrongful conviction shall reimburse the state for the compensation previously received, not to exceed the amount of the monetary compensation which the person receives in the subsequent civil action. Number one, currently the law allows a person to file both a criminal and then a civil action both, and keep the benefits of both. That's correct, right? Receive, enjoy the benefits of both.
Steve Yeager, for the record, that is not correct. Currently, I mean, they're both civil suits, by the way. It's not a criminal suit, but so there'll be a civil suit against the state of Nevada, and there'll be a civil suit presumably against a local government agency under Section 1983 of the Federal Code. Both of those are civil, but the current law requires reimbursement. There's not a double recovery option. What the section you're referring to does, it cleans up some of that language because, for instance, it says a settlement. So if the 1983 action settles rather than goes to trial, then we're clarifying that, you'd have to reimburse based on a settlement. So that just sort of cleans it up, but there was never an opportunity for someone to recover twice due to our fiscal responsibility. We wanted to make sure the state was compensated for a later award for the same conduct.
So I apologize. I meant in other matters. For example, we could take the matter of a famous former football player who was brought in an action in a criminal lawsuit and then subsequently a civil lawsuit, and there was a huge damages award in the subsequent one. But people are allowed in other matters to file both a criminal and a civil action and receive the benefits, whether they be the person's incarcerated or they receive money in both. That's number one. Number two, why would a person go through the hassle of filing a civil suit after they've already received the money from the state, the way that this is written, if they're going to have to pay it back? And number three, could this be considered like intentional or tortious interference with a private defense attorney's ability to earn a living?
Steve Yeager, for the record, I'll try to take those questions on. The first point you made, I think it's just, maybe it's not the best comparison because here we're talking about someone who was wrongfully incarcerated. Certainly, someone could be charged criminally and held liable, and then the victim of that crime could sue that person civilly. That happens all the time. It's just that the criminal prosecution's brought on behalf of a state or a government agency, and the civil action would be brought by the victim in the case. So you're right about that, but this is sort of the flip side of this. This is the person getting out and they can't file a criminal action, for instance, against the state. It's only a civil action. Number two, why would somebody file a subsequent suit? I mean, the truth is sometimes, not all the time, sometimes these cases are very egregious and the civil rights violations from the local government entities are just shocking to the conscience. In those cases, their case is going to be worth more than what the state is providing in this bill. I mean, some of these cases you'd be talking, multi-million, if not tens of millions of dollars. So, they might want to bring a second suit because they think they're going to recover significantly more money. And then even after reimbursing the state, they're going to come out way, way ahead. So that would be the reason why someone might file a second suit, and they'll talk to counsel about that and come up with what the appropriate strategy is. And then your third question, I think, was about tortious interference. And I'm not sure if you're talking about the attorney's fees provision, but I don't think that anything in this bill would amount to essentially a civil tort relating to attorneys, at least not that I know of. I don't think legal would have drafted it that way, but we can certainly talk more about that offline, but I don't think there's anything in the bill that in my reading would allow that.
Thank you very much for your answers. I remember this bill from last session. I remember the testimony of Mr. DeMarlo Berry. I think it brought most of the committee members to tears. And I just don't like to see where someone who was wrongfully convicted through no fault of their own and imprisoned now is, going to get nickel and dime by the state. Sorry.
Thank you, Assemblywoman Krasner. Steve Yeager, for the record, I would not characterize it that way at all. I think we've heard of the ones that have been settled, and we're talking, multi-million-dollar settlements that, again, the state did nothing wrong in these cases. So, the state is not probably not legally responsible for the compensation. But I think, as you referenced last session, the testimony was so compelling that we felt obligated for the state to step in and help out. And hopefully those people can actually hold the actual folks who should be accountable, and then, the state would be made whole. So I don't want to give the impression that it's nickel and diming. I don't think it is. I think that recovery is crucial for them getting their life back together and probably holding the actual entity that should be responsible.
Thank you for your question, Assemblywoman Krasner. I think we have one last question with Assemblyman Miller, and it kind of follows up on what you just said, so I'll let him ask that.
Thank you, Madam Vice Chair. Thank you for bringing the bill forward, Chair Yeager. My question is in follow-up to what you just mentioned, that the state not being legally responsible for these convictions. If I understand correctly, most of this is happening at the county level. So how do they participate in the sharing of the cost of these awards?
Steve Yeager, for the record. It's a great question, Assemblyman Miller, and one that we debated at length last session and perhaps are still debating. But, right now there is no direct provision in this bill or in this area of the NRS that would require any sort of sharing of the burden by the local government, whether it be a police department or a prosecutor's office. But I will say, much like I answered in the last session, it's not atypical in these cases for the individual to file an action against those entities. And, if through the settlement of that case, or if they go in front of a jury and a jury decides the local government did engage in wrongdoing, then that local government is going to have to pay the claimant. And under this statute, the claimant will have to pay the state of Nevada back. So we put that in there to make sure that we're protected. And again, so the record's clear, I don't want to suggest that in every case that there was some kind of intentional wrongdoing. I mean, we're human beings, and we all know our criminal justice system has been woefully inadequate in the past decades of protecting people in the way that it should. But if a jury decides that there was intentional wrongdoing, you're going to have a huge amount of damages, and the state will be able to recoup in that way. And, I don't want to get too far down this rabbit hole, but some of those discussions are ongoing about, should local government entities be able to participate in these lawsuits in some fashion? And if so, how? And if they do, is there a cost sharing or some kind of method to determine fault? And so I think we're really far away from figuring that out because it substantially complicates these claims. We don't want them to be like the 1983 claims where they take 5 years. The whole point of this was supposed to be quick, and credit to the Attorney General's office. I mean, this law's only been on the books like a year and a half, and they've done tremendous work in getting these cases processed and getting compensation. So hopefully that answers your question, and I wasn't too wordy in a lawyer fashion in that answer.
No, thank you. It answered the question. Thank you, Madam
You know what? I saw one other question. I have multiple chats going on here. If we could go to Assemblywoman Hardy, and then I will close the questions at that time.
Thank you, Madam Vice Chair. I was just curious in Section 3A, the different amounts, the 50,000, 7,500, how would those determine? Is that like an average of income of, just wanted to know how those figures were determined.
Steve Yeager for the record. Thank you for the question. That's an excellent question as well. And I'll fall back on the, there were a lot of people who helped on this bill. And one of them who helped was a young lady named Caitlin Herndon, who was interning for one of our Nevada Supreme Court justices. So she did a 50-state survey, and she didn't have data on all 50 states because not all 50 states have a law like this, but I want to say about 30 did. So they were sort of all over the map in terms of how they approached it and what the amounts were. Some gave a lump sum, some gave an amount per year. So I think we put our heads together and we kind of said what would be right for Nevada and what's a number that we can settle on. But it was also important to me that I wanted Nevada statute to be among the best in the country, because often we're criticized for not doing things well, and I wanted us to be a model. So we settled on these numbers, really just sort of doing the best we can and looking at what was out there. And I am proud to say that I think the states that remain to pass legislation like this have been looking at Nevada's legislation as a model. It is seen as best in the country in terms of how we structured it. So not a scientific answer, but we just kind of said, hey, we think you should get more money if you're incarcerated for more years, and came up with something that I think wasn't going to bankrupt the state, which was a concern as well.
Thank you.
Well, thank you for your presentation on Assembly Bill 104. Having sat through the presentation and being able to pass that bill last session was one of the most memorable things that we did last session, at least in my opinion. So at this time, we'll start testimony in support, opposition, and neutral of Assembly Bill 104. Please remember to clearly state and spell your name and limit your testimony to 2 minutes. We will be timing each speaker to ensure everyone is given a fair opportunity to speak, and we will limit the testimony likely to 20 minutes in support, opposition, and neutral on this bill. And staff from Broadcast Services, can we see the callers in the queue? And we'll start with support testimony.
Good morning, thank you. We will begin with callers wishing to testify in support. Please press *9 now to take your place in the queue. Callers wishing to provide support, please press *9 to take your place in the queue. And the public line is open and working. However, there are no callers to testify in support.
Thank you. So if we could go to opposition testimony.
For callers wishing to provide testimony in opposition, please press *9 to take your place in the queue. And we will begin with caller with the last 3 digits of 611. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Madam Vice Chair and members of the Assembly Judiciary Committee. This is John Piro, Johnpiro, from the Clark County Public Defender's Office. I want to thank Chairman Yeager and the members of the Attorney General's Office for speaking with us. We are in opposition today per the rules of the committee because we believe the bill leaves out an important section of when a person is incarcerated. Currently, as the bill is drafted, it says you would receive compensation only after the time you were wrongfully convicted. However, there is time that you spend in jail waiting for your case to go to trial, and those are years of your life that you lose as well. And so we would like to see an amendment in the bill that accounts for those years if the person can prove that they had spent the years in detention, pretrial detention, incarcerated in a county jail, waiting for trial, not being held on another case, So you wouldn't get compensation if you were going to be held anyways on another case, but on the particular case that you are wrongfully convicted for. And so that is where our opposition lies. Otherwise, we absolutely supported AB 267 last session, and we are grateful for all the work the chairman and the AG's office has done taking on this issue. And that concludes my testimony.
We can go to the next caller in opposition.
Thank you. Next caller with the last three digits of 080. Caller with the last three digits of 080, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Hi, Jim Hoffman for Nevada Attorneys for Criminal Justice. We would echo what Mr. Pirro just said. We are currently in opposition to this bill, but we are hopeful that we can get this language fixed and move into support. Thank you.
Thank you for your testimony. If we could go to the next person on opposition.
Next caller with the last three digits of 037. Caller with the last three digits of 037, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, spelled Tonjabrown, advocates for the inmates and the innocent. We are in opposition of this bill. I have provided you with a proposed amendment to this bill that we support. We would like to see in section 3, subsections 1, 2, and 3 to include additional subsections, starting with subsection A1 to remove the word imprisoned and replace it with arrested. So from the date the person was arrested after his or her wrongful conviction until the date the wrongful conviction was reversed or the person was released from prison, whichever is earlier, or I've included subsection 2 with the exception of those who have become deceased while his or her appeal was pending and the court prior to receiving a death notification had deemed he or she factually innocent, or 3, the Nevada State Pardons Board Commissioners has deemed he or she factually innocent posthumously, or 4, calculation for the compensation for the factual innocence posthumously will begin from the time of his or her arrest up into including the time that he or she would have appeared before the parole board for he or she's sentencing eligibility for parole to the streets, or 5, if the person was given a life sentence without the possibility of parole and died prior to the 21 or more years calculated of the bill, the estate will receive the maximum allowed awarded by the state of $100,000 for each year they have served. And I've included that to go into sections 2 and 3 as well. Thank you.
Thank you, Broadcast Services. If we can go to the next caller.
Thank you. Next caller with the last three digits of 556. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT. Opposed to the bill. The wrongfully convicted have already suffered the ultimate injustice. The stigma attached to the conviction will plague them long after exoneration. Their nightmare begins day 1 at the false arrest. Thus, compensation should begin then as well, not at time of conviction. Look at how long people are waiting for trial now due to COVID-19. 1 day in jail wrongfully convicted is wrong, let alone years. I would support Tanya Brown's amendment that she did just mention. And also, I understand the state's need to financially protect itself. However, we should start at the forefront of where these wrongful convictions begin, and that's by prosecuting the DAs who willfully have withheld exculpatory evidence to cause this wrongful conviction. Not in all cases, but in some of them, that is the situation. Thank you.
Thank you for your testimony. If we can go to the next caller in opposition.
Caller with the last three digits of 318. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Vice Chair Nguyen and members of the Assembly Judiciary. This is Kendra Birchie, Kendra Bertschy with the Washoe County Public Defender's Office. First, I want to thank Chairman Yeager for his hard work on Assembly Bill 267, as well as his work on this bill with the Attorney General's Office. We appreciate all that the Attorney General's Office, Assemblyman Yeager, as well as the members of this committee have done to assist those who have been wrongfully convicted to ensure that they are able to have the means to have a successful life ahead of them. Our only suggestion regarding this bill is regarding the term imprisonment. I would just echo the statements from the Clark County Public Defender's Office, and that our hopes is to ensure that we are able to provide a calculation that is fair and that is clarified in order to ensure that it makes it easier for everyone to understand what compensation could be due. Thank you so much for allowing me to testify, and I appreciate that the Attorney General's Office and Chairman Yeager have been so open and willing to discuss this bill with us, and hope to continue those conversations. Thank you.
We can go to the next caller in opposition, please.
Any further callers wishing to testify in opposition, please press *9 now to take your place in the queue. Callers wishing to testify in opposition, please press *9 now. And the public line is open and working, and there are no further callers for opposition at this time.
And then finally, I think I know the answer to this, but if we could go to any neutral testimony.
Callers wishing to testify in neutral, please press *9 now to take your place in the queue. Callers wishing to testify in neutral, please press *9 now to take your place in the queue. And there are no callers to testify in neutral at this time.
Thank you for that. Chair Yeager, do you have any closing remarks before I close the hearing on Assembly Bill 104?
Yes, thank you so much, Madam Vice Chair. First, let me thank the Attorney General's Office. They've been a great partner throughout this process, and honestly, they've done most of the work, so I want to thank them for helping me with this. I hope the optics don't look bad that I had 5 or 6 people in opposition and nobody in support. But I think the opposition comes, they come from a good place, and that place is, look, injustices have been done, and we ought to compensate people for that. And I agree with that 100%. Let me just tell you why I'm not quite there on that proposal. Number one, we didn't compensate anybody until we passed the bill last session. So this is a new statute, and we're certainly better than we were before. And the request really is to compensate folks for pre-conviction incarceration. And as many of you know, people are incarcerated, right or wrong, they're incarcerated all the time before they get to trial. And right now, if you're incarcerated before you get to trial and you go to trial and a jury acquits you, the state doesn't compensate you for that time. Maybe the state should, but right now we don't. So I think adding that provision would be somewhat inconsistent with how our criminal justice system works. And then in addition, as you all know, we've talked about how it's not really the state who probably is legally responsible for these damages. So I think as all of us being fiscal stewards of the state's money, we have to try to narrowly craft something that balances the interests at play. I think we've done that here. And then finally, keep in mind that many of these cases, they're going to file a federal 1983 action. And so in the most egregious cases, in a sense, they're going to get compensated for that pretrial incarceration if they're successful in that subsequent litigation. But if they don't file that litigation, it's the state who has to pay. So I think we have struck the correct balance I'm not immune to their concerns and their cries to do more. I often wish the state was in a position to do more, but I think here we struck that appropriate balance. So, Madam Chair, I'm going to continue working on some of these issues to make sure we have this bill just as perfect as it can possibly be before we would get to a work session. And I want to thank you and the members of the committee for your time and your questions this morning and for allowing me to present Assembly Bill 104.
Thank you, and I have no doubt that you'll continue to work on Assembly Bill 104 to make sure that it is the best version of that bill that we can have before we work session it. With that, I will close the hearing on Assembly Bill 104, and I will open the hearing on Assembly Bill 107. Assembly Bill 107 revises the procedure for determining whether a person may prosecute or defend a civil action without paying costs. I know that Chair Yeager also emailed out his conceptual amendments this morning on Assembly Bill 107, and will be presenting off of those proposed amendments. I think similar to Assembly Bill 104, there are some potential other amendments or other proposals that have been presented, and at this time he's going to continue working on that. But with that, I will turn this over to Chair Yeager to proceed with your presentation.
Good morning, Madam Vice Chair, members of the Assembly Judiciary Committee. My name is Steve Yeager. I represent Assembly District 9 in Southwest Las Vegas, and it is a pleasure this morning to present Assembly Bill 107 to you. Madam Vice Chair, with your permission, how I would like to proceed this morning is to make some brief introductory remarks. Then I'm going to hand it over to Bailey Bordelin, who is joining us this morning on the Zoom, and she's going to explain what Assembly Bill 107 does, as well as the conceptual amendment that I hope you all have, or if you don't have it, it should be up on Nellis. Thankfully, it's not terribly long. And then after that, we would be happy to answer any questions. If that's acceptable, Madam Chair, I'll make those remarks and then hand it over to Ms. Bordelin.
Perfect.
And I do want to, much like the last bill, I want to thank Ms. Bordelin, who really helped me on this bill. She did most of the work, talked to most of the interested parties. So it's a pleasure to be able to bring the bill. So this bill is about access to justice, and access to justice is obviously important. And the inability to afford court filing costs should not serve as an impediment to having your day in court. Assembly Bill 107 is a bill that will improve access to justice because it gives the court more guidance on how to determine whether a person should be relieved from having to pay costs to get into court. And as I mentioned, Madam Vice Chair, I've provided a conceptual amendment, and with your permission, I would like to hand it over now to Ms. Bordelin, who will take you through the bill as well as the amendment.
Perfect.
Great, thank you. Good morning, and thank you for having me on the Zoom, as our chair is calling it. My name is Bailey Bordelin, and I represent the legal aid providers in the state of Nevada. So since this is my first time this session, I will run through those real quick. Legal Aid Center of Southern Nevada, Washoe Legal Services, Southern Nevada Senior Law Program, and Volunteer Attorneys of Rural Nevada. So statewide, we provide free legal services to folks that can't financially afford attorneys for the legal help that they need. So this bill is about the fee waivers, as Chair Yeager mentioned, that are required to allow people who can't afford to file those actions with the court to proceed so that there's not a financial impediment to their ability to access justice. The courts have been a great ally and partner in our mission for access to justice and in promoting that throughout our legal system. So I did just real quick want to read you the access to justice mission statement for the state of Nevada, and it is: access to justice and equal justice under the law is not merely a caption on the facade of the United States Supreme Court building. It is perhaps the most inspiring ideal of our society. It is one of the ends for which our entire legal system exists. It is fundamental that justice should be the same in substance and availability without regard to economic status. So by and large, our fee waiver system allows many people, thousands of people every year to proceed, but it's not specific in who that should apply to. And so what we found is really just inconsistent results across the state. The courts have kind of been left with that policy decision of who should we find to be an indigent person and who shouldn't we, and what qualifies them. And so we think it's appropriate as a policy decision for this committee and this body to put in the definitions of who that should really apply to. I want to note that that's particularly important right now with everything going on. We have more legal need than ever. And this applies to all civil filings, whether you need to change your name, you need to get a divorce, you need to have a child's custody issue. But the big one for me that you all continue to hear about is that for an opportunity to defend yourself from an eviction notice, you have to affirmatively file with the courts an answer. And if you don't file that answer, your case can be summarily granted without ever receiving a hearing under Nevada law. So that costs $71 in Clark County, about $70 throughout the state. And that's a real impediment if the reason that you're there is because you didn't have enough money to pay your rent in the first place. And so as we move forward in this evictions crisis, and as we see those turn back on, we want to really make sure that we have clearly defined and allowed. And I will say in some cases, this is slightly expanding access to who doesn't have that financial barrier for an opportunity to defend themselves from losing their homes in a pandemic. Two examples that I wanted to provide you with. One is from when in the fall, some of the eviction protections were lifted and we saw those actions start to proceed en masse. We had an elderly gentleman who came into the court with a walker by himself. Him and his wife were in their 70s and he didn't want her to come to the court with him because he thought it was putting her at risk of COVID. So he was trying to navigate this by himself. She had lost her job that helped supplement their fixed income that they used to pay their rent and had received an eviction notice. They were denied for being a couple dollars over what they had set as a monthly limit. But again, they clearly didn't have that monthly income. And he actually, as he was trying to figure out what to do next and panicking in that moment, fell from his walker and was left the courthouse in an ambulance. And so this is really, we call those moments our legal emergency rooms when we're helping people figure out how to file because they're quick timelines and people need that help right then and there. So I think that's a good example of the need that we're going forward. And the other one I want to give you a family court context is we had a single mother of 4 who applied for a divorce from her abusive husband. She earned $1,800 a month, but because of the 4 children that she was attempting to take care of by herself, her expenses were $2,500 a month. Her fee waiver was denied, and she actually ended up waiting a few months until she could save up the $299 that it costs to file a divorce. So we think that these expansions that I'm going to walk you through really quick will cover those situations, and they are an outlier. Most people are qualifying, but we think it's important to close the loop and make sure that those people are able to access justice. So if you'll look at the bill, the real substance of it is in section 1, subsection 2, and there's an A through F listed there. And those are what we're putting in as the parameters for who qualifies for those fee waivers. The first one is an existing qualifier. If you are a client of legal aid, you can have your fees waived because we believe that the legal aid providers are doing that financial assessment before they have you become a legal aid client. You've already proven that you have a financial need, so we don't want to reinvent the wheel there. The rest of the categories are new, and we did do a 50-state survey and look at what's common and what other states are doing to allow access to justice. So B has the same idea as A. If you are receiving public assistance, we believe that you've already proven that you have a financial need and we don't need to require further burden to get there. C is a household income. We put 150% of the federal poverty line, and we've provided you as an exhibit what that means and what those numbers are based on how many people are in your household. That's where we will have a slight expansion in some courthouses because, again, every courthouse had set their own limit. So for an example, where the bulk of the work is in Nevada, the Las Vegas Justice Court had set that at 138%. So we are seeing a slight increase. 150% is what legal aid uses to determine qualifications for clients. So it would put some consistency in with the legal services that indigent people have access to. And then D is a safeguard. If you have a Lamborghini in a garage somewhere, you shouldn't have access. And I'll say that's a divorce case that I saw as a law clerk. So we want to make sure that you can't just say, I don't have this money in my bank account, and really you do have the means to pay the filing fee. And then E and F are to allow for a reasonable and human review of the unique facts of each situation. If a mom has medical bills for children that are having an outsized impact on her monthly income, that's something that we should take into consideration on a case-by-case basis. So there are a few friendly amendments that work through with that have been a result of the conversation with the judiciary. They have given me permission to represent that there are no remaining concerns, and so they're comfortable with this bill moving forward. Some of those language changes that you see are to allow for further automation and streamlining of legal services. Something we've been working really hard on during the pandemic is to allow people to file online from home so that they don't physically have to come in. And so as we're able to continue to build off of that, if there are ways to streamline this and allow this to proceed perhaps a little less formally so that we can do some of that automating and streamlining so people don't have to wait as long and it's not as much of a burden on court resources, we support that progress. As a side note, I'll say we're having a lot of conversations about the great work that we've made to automate and make access to the courts easier because of the pandemic. So we think the next frontier is trying to meet folks in the community where they're at with their legal needs. Before the pandemic, a lot of people had to take the day off work, get 2 buses, get down to the courthouse and figure out how to file. And so if we can bring the legal assistance to them where they are in their communities and help them figure out how to do it without all of that burden, that's something that we want to continue to build on from this moment. So that has been some silver lining to what's going on in the judicial system. I have Stephanie McDonald on with me, who is the director of the Family Law Self-Help Center in Clark County, because she sees a lot of these cases in and out every day. So to the extent you have questions on the logistics, I wanted her on to help me answer any of those questions. So thank you for the opportunity to present that.
And Madam Vice Chair, this is Steve Yeager for the record. I'm not sure if you wanted to go to Ms. McDonald, or if not, we are open for questions any committee members may have.
You know, I'll allow you if you would like to have her, testify. I'll give you that discretion.
Ms. McDonald, would you like to say anything about your experience? By the way, this is Steve Yeager for the record. Your experience on the ground and how this bill might affect that.
Yes. Thank you, Chair Yeager, and thank you, committee members, for considering the proposed legislation before you. My name is Stephanie McDonald. I am with the Legal Aid Center of Southern Nevada, and I am the directing attorney for the Family Law Self-Help Center in Clark County, Nevada, the 8th Judicial District Court. Of course, this is a statewide issue, as Ms. Bordelin mentioned, that affects all jurisdictions across the state. I, in my position, see, the multitude of family members who are filing various kinds of family law cases in Clark County, which is our busiest district court in the state. Our center assists those who are unable to afford an attorney. And while legal aid services do a great job of representing those without means, the demand for legal services far exceeds the ability of legal services to assist all of those individuals. So we are there to provide guidance, information, forms, instructions, explanations of the process to all of those who are navigating the system on their own. And we are very, very grateful to have this consideration because, as Ms. Bordelin mentioned, there is a bit of a lack of uniformity in how those applications are processed. It is sort of left to judicial discretion as to who qualifies and who does not. An application before one court could be approved. The same application before a different court could be denied. simply because there are varying measures of how the standards get applied. So we're excited about the possibility of having this legislation to provide more uniformity for all those throughout the state. And I'm happy to answer any questions that anybody might have.
Thank you. I appreciate that. It looks like we have a question here from Assemblywoman Hanson, so I will start with her.
Thank you, Madam Vice Chair. Thank you for the presentation, and certainly I agree that access to justice, it should not be deterred because a person cannot afford. So I have several questions. Well, let's just start with two. Currently, what happens when the court or the decision's made that the person doesn't qualify? If you're working with them, what recourse is there?
Yeah, I'll let Stephanie answer that. I will say the filing is not accepted until you are able to pay. So that is a real impediment to access to justice. But Stephanie, do you want to walk through that?
Yeah, thank you. That's Stephanie McDonald again for the record. It varies, quite frankly. There are some courts where the fee waiver is denied. It then becomes a matter for the clerk of court to continue sending invoices daily to the litigant, asking them to pay that fee. Some cases get dismissed by the court. There are some courts that are putting time limits on the amount of time a person has to pay. Oftentimes that might be 30 days from the date of the denial to pay the filing fee, or their case is dismissed. And in those cases are ending up getting dismissed. When a case is filed, somebody normally has 120 days to get the defendant served to move on in the process. The 30-day window of denial is resulting in cases being dismissed prior to their normal 120 days to prosecute a case. So again, the results of a denial are all over the place. And there is no recourse for somebody who's been denied. The statute previously, and in its proposed form now, does not provide an appeal or any kind of review for a denial of the fee waiver. So it ultimately becomes up to the court, the individual court, how to process that. And some continue on, waiting for the clerk to collect, some get dismissed. It's kind of a mixed bag right now.
And this is Bailey Bordelin for the record. And if I could add, in the evictions context that I was mentioning earlier, typically, if you're late on rent, you get a 7-day non-payment of rent notice, which is an extension that was put in last session. And that 7 days that you have to respond before the case can just be granted continues to toll pending a decision on your fee waiver and if denied. So in that situation, you have a very limited amount of time to find the money to file an answer.
And then I'm going to ask the question that I know is a no-no. I know it's a policy committee and not a money committee, but of course this is about money. So more a general jurisdiction issue. So if this bill were to pass and go into law, then it's going to, will the burden of the financial side of it be borne by the counties or the municipality, say a city, a portion of the state? I'm just trying to understand the structure, not so much how much money, but where the fiscal responsibility is going to lie.
Yeah, thank you for the question, Bailey Bordelin, for the record. So I will say that the courts did not feel that this was a drastic change in policy for any of them. So we did not get any feedback on how this would impact their budgets. They did very politely point out to me, and we had a conversation, that most of the fees in these filings actually go to the legal aid providers in the state. So we are proposing to take a hit in our own budgets because we think that it's important for the clients that we serve.
Great, thank you so much. Appreciate it. And I'm sorry, I have to get off the Zoom. I have a funeral to attend, but I'm glad I got to hear the majority of the bills today. Thank you so much.
Thank you, Assemblywoman Hanson. Be safe. I think we have a question next from Assemblywoman Cohen.
Thank you, Vice Chair, and thank you all for the presentation. I have a question about the existing language that we're not trying to change. But it just struck me as kind of odd being in practice. It's in section 1, the new sub 5. There's prevailing party language. And I just don't know if that's, I wasn't even aware of that. And I'm not even really sure if that's complied with by the courts. So I just wanted to know if that was something that you saw in your practice with legal aid, or if I'm just wrong that does get complied with.
Thank you for the question, Bailey Bordelin, for the record. So thank you for that follow-up question, because I should have mentioned that section 5 in my answer to Assemblywoman Hanson. There is a statutory provision that allows the courts, if the person who filed the fee waiver prevails in the action, which of course is not every case, but if they prevail, the court shall order the other party to pay that fee waiver that was previously waived. So should this cause a budget offset, you would be able to point to that as a way in some of these cases to recoup those costs. But like you, I personally do not see that used very often. I don't think we see it used very often. There are some contexts, because the fee waiver is across all types of filing cases, where it might be used more than others, but I'll say, having focused on evictions for the last 11 months, we don't see that used in those cases at all. So it is there, but we have not had conversations about amending it in context of this bill.
Okay, thank you very much.
Thank you. And I don't see any further questions. I'm going to do a last call out here. If you can just wave your hand if you have any. Oh, I see one here. If we can call Assemblyman O'Neill.
Thank you, Madam Chair, and hopefully this is quick. In the conceptual amendment, it says add to section 1.1, such application shall include an unsworn declaration under the penalty of perjury. I thought to have penalty of perjury, the declaration had to be sworn. I'm confused again.
Thank you for the question. That is the check and balance currently in place. If you'll see in the draft, we were using an affidavit, and the word affidavit throughout the bill is struck and replaced with the word application to try to move forward with a more informal process when possible, if easier for all involved. But there was a concern raised by the judiciary that an application doesn't necessarily require that penalty of perjury that the affidavit did. So we wanted to ensure that that check and balance stayed with the existing process. So that was amended back in.
So, Madam Chair, if I may.
Go ahead and follow up.
So the application, is that how to get perjury, you have to be able to prove that the person falsified the information. If they're not swearing to it, then maybe I better look at the perjury statute. Maybe that will clarify it. I just didn't know you could be prosecuted for perjury on an unsworn statement, period. Whether it's called an application, declaration, or anything else.
Bailey Bordelin, for the record, I'm not sure if Stephanie knows the ins and outs of that. I just know that the unsworn declaration with the penalty of perjury was the existing practice and complies with the related court rules. But Stephanie, do you have anything to add?
Okay.
Yeah, absolutely. Sorry, go ahead, Assemblyman.
No, if that's the accepted practice, then I'll accept, I guess. Thank you. Unless, did you want to add to clarify for me then, please?
Sure. Stephanie McDonald for the record. I'll just follow up real quick. The prior traditional practice within the courts was just about everything required an affidavit attached to it, which requires a notary, all the bells and whistles of what legal documentation traditionally includes. NRS 53.045 has been in place for quite some time now, which has largely replaced the use of those affidavits that require a notary. is another mechanism of providing greater access to justice for people who don't have the ability, time, means to get documents notarized. And so pretty much all of the self-help legal documents right now that people are using employ that unsworn declaration in lieu of the affidavit. And the language that actually gets attached to it is, quote, "I declare under penalty of perjury that the foregoing is true and correct." And that is the widely accepted practice within the courts that allows those legal documents to be filed and acknowledged and accepted without the use of a notary.
Very good then. Thank you.
I will concur with Stephanie's statement. I know in practice that we almost all exclusively use declarations instead of affidavits any longer. I do see I have another question from Assemblywoman Hardy, so I will turn it over to her.
Thank you, Madam Vice Chair. I actually worked in the civil division, and so had a lot of experience with these fee waivers and the frustrations of people coming in and, under a time limit and not knowing how to fill the form out, and, we couldn't answer their questions. So I appreciate clarifying some of this and having a new form. So I just wanted to ask a few things about the form. The previous form was just one page and, they just pretty much filled in amounts and stuff. So is this new application, is it, more detailed? Is it just yes, no questions? Do they have to put amounts, or, say someone doesn't have legal aid or someone helping them, just kind of if you could give us a little information about the ease or details of the form, the new application.
Absolutely. Thank you for the question, Bailey Bordelin, for the record. We work very hard as a state judicial system on forms. Forms are a big thing that we spend a lot of time revamping and reworking. So we do have fee waiver forms that we have developed. It's always a struggle to get those accepted as a statewide form because each court operates in a different manner. So we do spend some time as legal aid trying to adapt those as necessary for each courthouse to accept. I don't foresee that our self-help forms would need to be drastically changed, but should this bill pass into law, we would take a look at how to amend that to be acceptable. And we really like the proposed language in this bill that says on a form provided by the court, because that will help us with that form process and working with the courts to have an easy to use, easy to understand uniform process for anyone, regardless of whether or not they're a client of legal aid, to be able to navigate how to access the fee waiver.
Thank you. That's good to hear, because so many times these folks would run upstairs at 5 minutes to 4, and we're like, we can't help you with it, and then they're just frantic, and so I think that's good, and especially if they're going to be doing these e-filings from home and such. The ease of the form would probably be very beneficial. So thank you.
And do we have any other questions here? I don't have any that have been messaged to me, but if you can raise your hand or wave your hand if you have any questions. I see one from Assemblyman Ornlicker, so I'll turn it.
Thank you, Madam Chair. I just want to make sure I understand when Section 2D, the sufficient legal liquid assets provision. And the way you explained it, the example you gave made it sound like you were talking about somebody who might qualify under some other provision, but say C, the household income, but actually has ample assets that they could draw on. And so it sounded like you were saying we wouldn't want that person to qualify. So if I'm understanding that example, I'm not sure D works that way because it's an or. So was that your intent, to have it as a to not let that person qualify even if they qualified under another provision? Or did you really want it as an independent provision?
Haley Bordelin, thank you for the question. I understand what you were saying. My example may have been a little rushed based on how we previously have or currently are handling these. In my experience, we are asking people if they have these liquid assets, but the way that we are moving forward with these, if you are able to prove need under any of these, you would be able to move forward. Stephanie, do you want to add anything on that?
Yeah, it's Stephanie McDonald for the record. You know, I don't think that circumstance presents itself terribly often. Under the current version of the application, litigants are asked for their household income alongside a listing of generally, you know, whatever assets they have, which typically includes a house or a car or a bank account. And so the court is sort of looking at that as a whole. It is the very rare circumstance where somebody would show income below the threshold amount, but have assets in great amounts that would allow them to pay for the filing fee. Should, you know, within the family court context, there are generally additional financial disclosures that get submitted, and should it come to the court's attention that maybe somebody got through on a waiver that they shouldn't have received, the court always has the power to revoke it later if appropriate.
Thank you.
Thank you. And do we have any other questions here from the committee? Seeing none, I think we will start our testimony in support, opposition, and neutral of Assembly Bill 107. I'm going to remind the public to please clearly state and spell your name for the record and limit your testimony to 2 minutes. And with that, we will begin with support testimony of Assembly Bill 107, Broadcast Services. Can you add our first caller?
Thank you. For callers wishing to testify in support of AB 107, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 956. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, and thank you, Chair. My name is Liz Davenport, Lizdavенport, the legislative extern speaking on behalf of the ACLU of Nevada. As the presenters explained so well, a guiding pillar to the courts and justice system is to provide, quote, equal access to justice for poor and rich, weak and powerful alike. People have never ceased to hope and strive to move closer to that goal, as stated by the Supreme Court in 1956. So AB 107 will allow Nevadans greater access to Nevada's courts and provide a consistent method to removing financial barriers in accessing the court system. A clear and objective standard to granting fee waivers is more important than ever right now. Poverty should never be punished by forcing unequal access to justice. Existing law does not provide Nevada's courts with a clear and objective standard for granting fee waivers, and further does not provide an applicant with clear guidance. AB 107 makes these positive changes in providing courts with a clear, consistent method, and also provides applicants with clear guidelines into eligibility for a fee waiver. The ability to access the court system should be open to all. A court fee should not be a prohibitive factor. The ACLU supports equal access to justice and supports AB 107. Thank you for your time.
Thank you. And I know that that was Ms. Davenport's first time testifying on a bill in committee. And I would be remiss if I didn't point out that she is a Boyd student, and I am a Boyd graduate, a proud Boyd graduate. So I know that we will see some of the same people testifying over and over again. So welcome to the Assembly Judiciary Committee. And with that, can we go to the next caller?
Next caller with the last three digits of 037. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, spelled TONJABROWN, advocates for the inmates and the innocent. We support this bill. I would like to make a comment dealing with the assets. Now, there has been a time or two where dealing with in the matter of an estate, and the estate has no money, and there's an administrator appointed. They're required to pay the filing fee. So I think that's something that should be looked at. That should be waived. There may be very little asset that in the estate, or maybe future assets, say a car accident and somebody was killed, but they had no assets at the time, but will in the future. So they kind of look at that, and they'll get hit with the filing fee. So, but other than that, yes, we are strongly in support of this bill. Thank you.
Thank you. If we can go to the next caller in support.
Caller with the last three digits of 611. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Madam Vice Chair and members of the Assembly Judiciary Committee. This is John Piro, JOHNPIRO, from the Clark County Public Defender's Office, and we stand with our colleagues from Legal Aid in supporting this bill brought by Chairman Yeager. This is an access to justice issue, and it does affect our clients in that filing fees can sometimes prevent them from moving forward with sealing their records. So this would open up the doors to more record sealing and helping our clients move forward in their life. Thank you, and that concludes my testimony.
Thank you for your testimony. If we could go to the next caller in support.
Next caller with the last three digits of 419. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Thank you, Vice Chair Nguyen and members of the committee. For the record, my name is Benjamin Challinor, BenjaminChallinor. I am the Policy Director for Faith in Action Nevada, a statewide nonpartisan multi-faith organization that organizes and advocates for racial, social, and economic justice, as well as an inclusive democracy. We are here in support of AB 107 with the proposed amendment. Thank you, Chair Yeager, for bringing this bill forward. I would like to echo the previous speakers. Poverty should not prevent access to justice. Those who are already suffering should not be put through even more, especially when it comes to housing. Nevada already has an imbalance of power between tenants and landlords, and this is one step towards settling that, especially for those who are on fixed incomes and receiving public assistance. In addition to eviction defense, this would also apply to security deposit disputes, which we have seen some landlords hold against their tenants. Many times, especially for those who could receive these fee waivers, that means whether or not they'll be able to move into their next home due to their security deposit being held up. AB 107 makes sure that we can actually help those who are in need in these civil procedures. Thank you.
Thank you. If we can go to our next caller in support.
Caller with the last three digits of 318. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning again, Vice Chair Nguyen and members of the Assembly Judiciary. This is Kendra Birchie, Kendra Bertschy. I want to thank Chairman Yeager and Legal Aid for bringing forward this important legislation. As the other callers have indicated, this is extremely vital to ensuring equal access to justice for all Nevadans. I would just note that, as I mentioned in my presentation about the Washoe County Public Defender's Office, oftentimes our clients have collateral issues involving the legal system which this bill would allow them to ensure that they are also able to take care of those matters that may have brought them into the criminal realm, but also to ensure that they are able to become productive members of our society. So I really appreciate this, as well as having volunteered with a lawyer in the library and having processed fee waivers as a law clerk. I can just mention that the examples that Bailey provided, or Ms. Bordelin provided, weren't just the wild, crazy exceptions, but those are occurrences that do occur very frequently. And so we appreciate this bill. Thank you very much.
Thank you. If we can go to the next caller in support.
Next caller with the last three digits of 755. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Chair and members of the Assembly Judiciary Committee. My name is Tess Opferman, that's spelled Tessopferman, speaking on behalf of the Nevada Women's Lobby. One of our top priorities of the Nevada Women's Lobby is housing security, especially now through the current pandemic. We want to ensure women and families are able to maintain affordable and stable housing, which has been made even more difficult by the high rates of unemployment, something that has disproportionately affected women. We support this bill as it removes a financial barrier in access to justice and ultimately can provide housing security. Thank you to the sponsor, Assemblyman Yeager, for bringing forward this bill, and thank you to the committee for your time.
Thank you. If we can go to the next caller in support.
Next caller with the last three digits of 556. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE, I support the bill as it specifies what satisfies the inability to pay. Far too often people are denied aid or access to justice due to financial poverty, especially when pro se litigants are treated at the same standard as an attorney when it comes to filings, etc. Though the law says they shouldn't be, I am in support of this bill because it gives access to all. Thank you.
Thank you for your testimony. Do we have any other callers in support on the line?
Any further callers wishing to testify in support, please press *9 now to take your place in the queue. Callers wishing to testify in support, please press *9 now to take your place in the queue. And the public line is open and working. However, there are no further callers in support at this time.
Thank you. If we can go to callers in opposition at this time.
For callers wishing to provide opposition, please press *9 now to take your place in the queue. And we will begin with caller with the last three digits of 048. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Madam Vice Chair, members of the committee. Stephen Cohen for the record. Stephen with a V, Cohen as in the Assemblywoman, although no relation. Have a couple of concerns as a current pro se litigant that's had to navigate, particularly the federal pro se system. So first, this seems to be devoid of a screening requirement. Filing is kind of the first step, but then also the court is charged, at least the federal court, with ensuring that the claim is viable on its face initially. So the second issue, and I'm going to sound like a broken record, as I testified at length on this in the Senate yesterday. How do we reconcile access to justice with statutes of limitations? Because picking up where Madam Presenter left off with her example, especially now, it's conceivable that somebody could never have those disposable assets, for want of a better phrase, to actually pay the fees. So that's number two. And then number three is would also like to see for complex litigation, as mine is, because the problem I'm having is, because of who the defendant is, finding a lawyer that doesn't have a conflict of interest. So I'd like to see some better reconciliation with the LRIS, or Lawyer Referral Information System, through the state bar. And I stand ready, willing, and able to work with the sponsor committee and presenters to facilitate those changes. That, Madam Vice Chair, thank you, and I yield.
Thank you for your testimony, Mr. Cohen. If we can go to the next caller in opposition.
Any further callers wishing to testify in opposition, please press star 9 now to take your place in the queue. And the public line is open and working. There are no further callers in opposition at this time.
Okay. And with that, I will move on to neutral testimony. I believe we have several people testifying in the queue. So if we could start with those.
Callers wishing to testify in neutral, please press star 9 now to take your place in the queue. Callers wishing to testify in neutral, please press star 9 now to take your place in the queue. And again, the public line is open and working. However, there are no callers to testify in neutral at this time.
Okay, well, thank you for that. And with that, I will turn this back over to Chair Yeager to see if you have any closing remarks on this.
Thank you so much, Madam Vice Chair, members of the committee. Steve Yeager, for the record. I'll just make a couple of quick remarks and then hand it over to Ms. Bordelin if she wants to add anything. I just want to thank Ms. Bordelin and Ms. McDonald for being here, helping me present the bill. I want to thank those who testified in support. And really, you know, I don't want to ever lose an opportunity to thank the folks who do the really hard work of working for legal aid organizations. Attorneys are expensive and they're not always willing to take on cases. We have such a need in the state, and our legal aid providers step in as best as they can and fulfill that need to help real people with real problems every day of the year in helping them solve those problems. So I want to thank them for the work that they've chosen to do. I don't think we thank them enough. It's really hard work and sometimes not very rewarding. So I would like to thank them again. And Madam Chair would hand it over to Ms. Bordelin if she wants to make any concluding remarks.
Ms. Bordelin, would you like to make some closing remarks?
Sure. Thank you, Bailey Bordelin. For the record, I would like to similarly thank Chair Yeager for agreeing to work on this legislation with us. And I appreciate the time and opportunity we've had to discuss this and work through this, and the Judiciary for working with us on this and always being a great partner in the pursuit of access to justice. So I look forward to getting this legislation through. And if anyone has concerns or questions that come up after the fact, please feel free to reach out to me. And thank you all for all of the policy work that you guys are doing. I appreciate the time and effort that you all put into this.
Well, thank you, everyone, for the presenters and your testimony today. And then with that, I will close the hearing on Assembly Bill 107, and I would invite our chair back to the dais to take over the rest of the meeting.
Thank you so much, committee. Thank you, Madam Vice Chair, for running those hearings. It's nice to be out of that hot seat just for a little while. I'm sure I'll be back in it sometime soon, but want to thank you for listening to those bills. And so before we get to the very end of our meeting and announcements, I'd like to go to the last item on our agenda, which is the public comment line. As a reminder, we'll have up to 30 minutes of public comment. Speakers will have up to 2 minutes to provide public comment. BPS, could we go to the public comment line and see if there's anyone there who'd like to give public comment this morning?
Thank you. Callers wishing to provide public comment, please press star 9 now to take your place in the queue. For callers wishing to provide public comment, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 556. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIEGRANT. Sister Thomas Purdy, who was murdered by Reno police and Washoe County deputies during a mental health crisis. Today I wanted to tell you about Micah Abbey, who was killed by Reno police. Micah Abbey was 33 years old when he lost his life to Reno police 12/25/2011. He was in a group home for mentally disabled folks. He got into a verbal argument at dinner time with one of his peers. Staff called RPD. By the time Reno police officers Keith Pike, Daniel Bourne, Scott Rasmussen, and Brad Dimitropoulos arrived, Micah was resting peaceful and calmly in his bedroom by himself, sitting on his bed. Micah did attempt to resist arrest on Christmas Day. Of course, he didn't want to go to jail. The police tasered him 22 times, of which 12 of those he was handcuffed and face down with officers on his head, neck, and back. They also hogtied Micah, like RPD did to my brother Thomas Purdy. They used a baton on him as well. He never made it out of his room alive. I personally know Micah's family and so many other Washoe County families living the nightmare of police killing your loved one without consequence. Christmas is a dreaded day for Denise, Micah's mom. She works in a mental hospital for years and they didn't kill anybody. Truth be told, the only community member to die at a mental facility in Washoe County was Ronald Leach, who was a patient and was shot by Reno police in the parking lot. Please do not support bills that further protect bad cops. Support bills that promote transparency and accountability from police. Thank you.
Thank you for your public comment, Ms. Grant. VPS, do we have anyone else on the public comment line?
Caller with the last 3 digits of 037. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Tanya Brown, TONJA, Advocates for the Inmates and the Innocent. Good morning, Mr. Chairman and members. I would like to thank you for the hard work you have put into these bills. We truly appreciate that. When I have provided the committee with my proposed amendments to Assembly Bill 104, along with 2 exhibits. These exhibits are sworn affidavits under penalty of perjury. I do not see them up on Nellis, so I'd like to see them up on Nellis if that's possible. Also, in that proposed amendment, I stated under Section 3, subsection 1, excuse me, with the exception of those who have become deceased while his or her appeal was pending and the court, prior to receiving a death notification, had deemed he or she factually innocent, that should be, instead of has, should be would have deemed them. And I kind of touch on it because of the COVID situation. We have inmates who are appealing their conviction, and some have for many years. And should they die because of COVID or other health issues, they should not lose trying to exonerate their names. And also, correct me if I'm wrong, but it's also in part because of Mr. Fred Steese. I recall that Mr. Steese was tied up in court, and the judge was about to render their decision when Mr. Steese was approached for a deal, maybe an offer plea. Anyway, he took it prior to the judge deeming him innocent. So that, in part, is why I have that in there. Because once a person dies, and within 30 days, the courts are notified, and if it's even pending in federal court or even state court, and that court was going to determine that they were innocent, it should be in here, and I believe it should belong in this bill. I want to wish you all a happy, great weekend, and see you on Monday. Thank you.
Thank you for your public comment, Ms. Brown. VPS, anyone else on the line for public comment?
further callers wishing to provide public comment, please press star 9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no further callers at this time.
Thank you again, BPS, for all the work you're doing to make these meetings happen. At this time, I'll close public comment. Before we talk about next week, is there anything else from any of the committee members this morning? Okay, I don't see anything. Committee, it has, I don't know about you, but I feel like it's been a very long week. I'm happy it's Friday. I'm looking forward to trying to get some rest this weekend, and just want to thank all of you for your participation, your questions this week as we started to ramp up on the number of bills we're going to hear. In terms of what next week looks like, we will not have a meeting on Monday. So we're going to get Monday morning off from Judiciary. So please take advantage of that in whatever way you feel is appropriate. And then so far, I believe we have agendas out for Tuesday and Wednesday. Those will be 8 o'clock starts. Wednesday, we're going to try to get through 3 bills. We'll see if we can actually do that in this virtual world. And then sort of stay tuned for the rest of the week for Thursday and Friday, as we're still trying to build those agendas. So with all that behind us, thank you again, committee. And we will see you all on Monday morning. Have a great weekend. This meeting is adjourned.
Bye. Thank you so much, Chair and Vice Chair.
Goodbye.